Hey everybody, good afternoon. Good afternoon. I am here to bring you guys the update from YSL, the longest jury selection trial that I ever in my whole entire life have experienced. And I've been on this earth for how many years now? A lot of years. So finally, I'm telling you, a lot of years. Hey, Gucci. Hey, Nakenya. Hey guys, how you doing? Gucci, you finally get your butt up in here. Well, Gucci, I'm doing an update on YSL. Then after this, I'm gonna end this and do an update on Robert, so I can give you guys an update of what has been happening with Mr. Kelly. Okay. Where my people at? Where my people at? So, folks want to hear what's going on in the courtroom. So, we are in the sixth day of this trial. Not 6 days, 6 months. That's what I meant to say. 6 months of this trial. This trial has been going on for a long time. Hey, Laura, how you doing? This trial has been going on for a long time, and we have not even gotten to the opening arguments. But I'm going to go ahead and give you some updates. It's been a lot of stuff that has been happening, from jurors getting held in contempt. In fact, there was a couple of jurors that was held in contempt that the judge addressed, and he's going to address some recent ones soon. I think it's next week on the 12th, if I'm not mistaken. And tomorrow, there's going to be a hearing, and this hearing is going to be about the computer, Mr. Johnson's computer. There's a motion that Mr. Johnson submitted. And I'm gonna read all that to you guys. Let me just go ahead and bring that stuff up so you guys can get abreast of what's happening. And I didn't want this to be a super long live, but I guess I got to give you guys the information, huh? All right. So in the meantime, let me go ahead and bring you the video, and I'm gonna take the voice down because take the volume down because this is just hardship they're talking about, but I want to give you guys some footage and see some of the stuff, action that's going on within the courtroom. Let's just do that, okay? All right, let's go ahead and there's no volume on it, okay? Okay, I gotta stop it. Gotta come back in it. Hold on, let me go out and come back because I had it up for a while. I was watching it, and then I put the live on. And I'm gonna a lot of the family wants to see their loved ones, so this is for them to see them. Okay. Good afternoon, Edna. Okay, this is guys watching it. Okay.
Now I'm going to hand you back the supporting documentation because you have it notarized. Okay.
I'll keep it quiet. You want the volume? Okay, I'm gonna give you the volume. Okay, hold on. You want the volume? Okay. See, y'all such crybabies. Cause it's boring. Oh, thank you, Angie. Thank you, Angie. Thank you. Angie, I forgot.
Okay, thank you.
Thank you, Angie. Appreciate it. If you notice, y'all, you notice that Effinger is not using the computer now. Most of them are not using the computers anymore. They can look at it, but I don't think they can touch it. They can look, but they can't touch. You see that right there? Laura says, please don't forget to hit. Yeah, please don't forget to hit the like.
All right, counsels, juror 1265 has a properly executed affidavit for excuse or deferral from jury duty of a caregiver of a person over the age of 6. And the individual that is referenced in the particular document is her husband. And it's been signed and notarized. Do I have any further examination of juror 1265? No. All right. May I excuse juror 1265? Okay. Madam, I'm going to excuse you for hardship, okay? Or for statutory reason, I should say, and wish you the best, all right?
Thank you very much. Have a good day.
You're very welcome.
Yo, this is I really don't want to keep this long because it's boring.
Thank you.
Yeah, this is just the boring part. I got some stuff to show you, and I don't plan on being here all day with this. I just wanted to show you footage, and not hear this hardship stuff. I need to do this late at night. See, it's just so boring. See, I know you want to see. Okay, but I got some stuff I'm gonna show you. Well, okay, let me tell you something. Hold on. Let me go ahead and bring up the one that I need to bring up for you and explain to you what's happening, what's going to happen in the next couple of days, and then I'll play this at the end. How about that? Can we do that? Can we do that? Because this part here is very boring. The only thing I like is the footage of the individuals, you know, just seeing what they're doing and things like that. But as far as them talking, it's the same stuff, repetitive. Repeating the same stuff over and over and over, and it just gets so boring. I don't care to hear about. I really don't care to hear it. I was gonna say, well, I do want to hear it. No, I don't. But it's the boring part. But let me go ahead on and get the other thing so I can give you the update in regards to what's gonna happen tomorrow. Tomorrow there's a special hearing, and I want to tell you that I'm going to play the end of it for you guys so you can see what I'm talking about. What the hell? Let me put it up for y'all. Hold on. Let me put it up. Tomorrow there's a hearing, Mr. Johnson, having to do with that computer when they came and guy's computer did a what's the name? A subpoena for the computer. So there was a motion submitted. Okay, this is a video from today, y'all. This one's not gonna be too bad. I'm gonna play this one all the way out because we didn't stay in court that long, okay? Let's do this one. Let me put my watermark. Thank you so much, Angie, for reminding me about my watermark. Okay, here we go. I tell you, I'd be looking out for me. Thank you, Angie. Nice picture of Young Thug, right?
In the matter of the state of Georgia versus Cleef Adams et al. In 22 SC 183572. Let me go ahead and take roll at this point in time. Mr. I'm sorry? Okay, thank you. Mr. Beebe and Mr. Partridge. Good morning, gentlemen. Mr. Stillwell, Mr. Bronson, Mr. Sharp, good morning. All right. Mr. Williams and Mr. Adams, good morning. Good morning. Mr. Kendrick and Mr. Weinstein, good morning. Mr. Urey and Mr. Matthews, good morning. Mr. Nichols and Mr. Garner, good morning. Mr. Dorsey and Mr. Jimenez, good morning. Mr. Eppinger and Mr. Johnson, good morning. And Mr. Ryan and Ms. D. Williams, Good morning. Mr. Smith and Ms. Love, good morning.
Good morning, Your Honor.
Ms. Von Kels, good morning, and good morning, Mr. Randolph.
Good morning, Your Honor.
All right. Just a few things of administrative. Mr. Adams, I am in receipt of Mr. Steele's request to appear on Thursday, June the 1st, and Tuesday, August the 22nd for oral argument in front of the Supreme Court. I assume he's talked to you about these two dates?
Yes.
Mr. Williams, do you have any objection to Mr. Steele participating in those particular arguments, sir?
What's that?
All right. I'm going to include his letter as an next court exhibit. When we come up on those dates, just remind me again. But it's all right with me, all right with you. You talk with your client. I'm okay with that.
Will do.
All right. Ms. Von Kelch, good morning again, madam. I am in possession of several of your communiques with juror issues that I'm probably going to we just need to kind of work through. Let's start off with juror number 7.
Okay, now the judge is going to address a lot of jurors. Damn it, I'm telling you something. The jurors do not want to be on this case. Majority of the jurors do not want to be off this case. They're frustrated. They're in the point of their lives are being on hell because they have to keep, constantly call in and things like that to make sure and not make any kind of life expecting stuff. They can't go on vacation. They can't do any of that stuff because right now they're basically on hold. You know what I'm saying? They're basically on hold. So a lot of them are frustrated. They're frustrated. They want to get out and they can't get out because they have a duty to fulfill. And this is just not the norm, right? They're just sitting in limbo and they're upset. They're very upset. So a lot of them have been contacting juror services and making complaints and doing this, doing that. So the judge is about to address a couple of them, a couple of situations, and let's hear what he has to say, okay? Oh, why do that thing do that to me? I hate having to stop it because when you stop it, you got to go back and hold on. He gets on my nerve with this. It's just like, let's do it again. I think I can't stop these things in between. I have to let it keep going. All right, here we go. I'm not going to stop. I'm going to keep going because it's making...
Dates?
Yes.
All right. Mr. Williams, do you have any objection to Mr. Steele participating in those particular arguments, sir?
What's that?
All right. I'm going to include his letter as an next court exhibit. When we come up on those dates, just remind me again. But it's all right with me, all right with you. You talk with your client. I'm okay with that.
Will do.
All right. Ms. Von Kelch, good morning again, madam. I am in possession of several of your communiques with juror issues that I'm probably going to we just need to kind of work through. Let's start off with juror number 70. If you have that.
Yes, Your Honor.
Okay. Now, as I understand it, he's already had his hardship heard and denied in January. Is that correct?
That is
But
correct.
he keeps sending you notification that he wants to be reevaluated for hardship. Is that correct?
That's correct. He was in the very first group we did in the very early stages. He needed to return, I believe, with his juror policy perhaps, or a travel schedule, which he has since provided. I think he was under the erroneous impression that he would be coming back shortly after that time in January to re-present his hardship. He has contacted myself in January, February, March, and June, stating that he cannot perform his job duties effectively, knowing that he's going to have to come back at another date.
Well, you can advise him that I discussed that with the lawyers here in open court, and that he will have to come back whenever it is we tell him his panel is going to be examined. And at that point in time, we can he can bring in his juror policy from Georgia Tech, and he can also at that point in time facilitate, because I cannot adjudicate, even though he's provided dates and other information in a vacuum without counsel's permission. So you can just tell him that it's not up to me necessarily, but since he's gone through that particular process that I have to get attorney buy-in. So if you could tell him that, and in the absence of that, I can always schedule him for a contempt hearing if he continues to berate you.
Understood, Your Honor. Thank you.
Okay? All right. That's number 70. All right, number 520. She has kind of a similar situation. Is that correct?
Yes, Your Honor. I would characterize her correspondence as abusive. She initially threatened suicide if she could not have her hardship heard. At that point, it was about anxiety and depression. Now she also was alleging her mother was sick and she was going to have to fly back.
Did you hear what she said? Did y'all hear what she said? She said that the juror says that she was gonna commit suicide if she doesn't hear her hardship heard. She has anxiety and all this other stuff. Did you guys hear that? Did y'all hear that? Oh my Lord. Okay, let me finish playing that.
From Atlanta to Maryland to take care of her mother. That was back in January. She has now renewed this in June, and she is all of a sudden her request is urgent, and she
says she can't wait till July 14 or thereabouts. Is that correct?
That's correct. She admitted that she's coming back and forth from Maryland and Atlanta, and I told her we're happy to work with her schedule. We have various jurors traveling. We track all of the unavailability, and we would certainly do our best to work with her on a date that is convenient for her schedule.
Yes, I have. I've taken a look at the correspondence that she has given you, and she's. I think what you told her is absolutely correct, that she doesn't need to call back until July the 14th. She seems to not be accepting of that particular answer, and has basically accused you and the rest of us of wasting tax dollars and the like. And I would just kind of put her in the same category of you can tell her that the judge has discussed this with in open court with counsels, and that she can present her additional issues on the when we call her in, because I have to get counsel's buy-in on several of the issues that she's raised. but she has to be patient. You can tell Juror 70 that as well. The patience definitely, I mean, we'll probably adjudicate this thing, but I do have to get counsels from both the state as well as each individual defendant's approval. So I can't just excuse her just based upon what sending you correspondence, and that would be continue to do that would be improper.
Thank you.
Okay. All right. The last one is Juror 568. Is that correct, madam?
Yes, Your Honor.
And she is moving to North Carolina. Is that correct?
Yes.
All right. He is moving to North Carolina, I should say. Have we already examined him?
I believe so, Your Honor. But he, either that or he did not have a hardship, but he now has a change of circumstances. And he also, in my communications with him, let me know that he has an 11-month-old daughter.
Let me take a look and whether or not we've examined him in all 568. Let's see.
Awesome seizures.
Counsels, we did in fact examine Juror 568 at an earlier date. He's a gentleman that he originally tested positive for COVID. We rescheduled him. We did get through his hardship being financial, and he did pass hardship muster. He has now provided a email which would indicate that he's moving to North Carolina, but for our purpose as well, he's also provided an affidavit for excuse or deferral from jury duty for childcare, and he has an 11-month-old. And I would ask your assistance with adjudicating this. Do you want me to go ahead and excuse him for hardship?
No objection, Judge.
Okay, fine.
That number one more time, Judge.
568, sir. 568. He's moving to North Carolina. I'll include the email correspondence between Juror 568 and Ms. Von Kelsch. It does give his daughter's age, and he does have the affidavit, which has been signed and notarized, and he does indicate that he's moving to Raleigh, North Carolina. Okay?
Yes, sir.
All right. So I'm going to go ahead and excuse him. You can mark your records accordingly. 568 is going to be excused for hardship. So Ms. Von Kells, we'll go ahead and include that as documentation, and you can let him know that he can be excused officially as of now. Okay? All right. Thank you, ma'am. All right, Ms. Von Council, any other administrative I need to go through, or we satisfied the administrator for the morning?
We do have the group 6 fund drives, as well as the group 7 panels and bios. And I just wanted to advise council, I've never been here when these were passed out, so I wanted to let them know what the contents are. We send these off for scanning on June 2nd. So any jurors who have not
Now, go ahead, okay.
any jurors who have not yet been excused or who were scheduled for a hardship after June 2nd will be included on this USB drive. And then we've also, we've included those with no hardship, those whose hardship was denied, those whose excusal status was unknown at the time of scanning, and the jurors who claimed a hardship but missed their hardship hearing dates and did not respond to jury services inquiries to reschedule. Thank you, Your Honor.
All right, you want to go ahead and hand those out, please, madam? Between you and Mr. Curtis. Councils, if you will go ahead and facilitate that distribution as well, you can.
Hold on. Hold on, I just got a cash app. Thank you, Bree. So much money.
Yes, if I could again use the services of Jimenez and Associates Technology, please, sir. Yeah, and he'll check all of them, and then that will at least, and we'll be able to get an eye sign in terms of if they're all scanned. Okay.
You got Brian's and Bob's. You need two for Brian, okay? One for them, one for you. You actually get one more? Let's see what's what. Okay. But I got you. Get you, I need one. I need two. I'm going to go ahead and grab one for our jury consultant.
Thank you, sir.
So we're gonna get past the jurors here. Hello. We're gonna go get down to this is Juror. We bypassing the jurors part, okay, y'all?
So if you were here with us about
My mother, who passed away just a few months ago.
I'm sorry to hear that.
Thank you. So now I'm in the process of moving her into independent living.
Okay. And you started the process of doing that at
Yes,
this
sir.
point in time?
Yes, sir.
Okay. Tell me what a typical day for a week for you is taking care of your sister.
Yeah, so she has a seizure disorder as a result of the brain injury. So
What? I'm sorry.
a seizure disorder.
Okay, yes, ma'am. Okay,
Yep.
thank you.
So she has episodic difficulties that include clusters of seizures, falls. As a matter of fact, she suffered one on Monday. And she does that. I am usually her text lifeline in order to be able to determine if she needs to go to the emergency room or to a doctor. I have a network of folks there on the ground who provide transportation, et cetera.
Okay, and I take it that your job gives you great flexibility to take care of your sister?
Yes, I work for a healthcare company.
Yes, Village MD, is that correct?
Yes, sir, and they're aware of the situation.
Mr. Smith, anything further? Anything further may have any individual defendant? May I excuse jurors 16, 17 for hardship? All right, Madam, excuse you. 130. All those, you're still subject to. Yeah. Okay, all the best, okay? Thank you, sir. All right. This in the street, you do have some neurological issues, is it? Let me just ask you the question as well. Is the travel that you're asking me to consider, was it booked prior to March the 24th of this year?
Yes, sir.
All right. Can you show me or tell me what dates, if any of those, and I take it that you are self-employed, is that correct?
Correct.
And per month? Just
At least 1,000.
okay, all right. Any other expenses that you're paying other than the mortgage and the gifting to your family in varying amounts that you're paying every month? Car note, any other taxes or any other things that?
Taxes.
How much are taxes every month? You making 941 payments or estimated tax payments? Okay, how much? Guesstimate? You're thinking too hard. How much?
I'm sorry, I'm sleep deprived. I can't remember that. I just got off of the flight. I'm sorry.
Fair enough. All right, madam, do you have any money in checking and savings?
I do.
How much?
I'm checking 4,000. Savings 10.
Okay, all right. Now, if you were here about, 6 months, would it be fair to say that you would lose some of the business that you have booked as a consultant and as a DJ?
I would lose all of my business.
Okay. And would you lose, based upon last year's income, at least $45,000?
Yeah.
Have to expend this money you have in checking and savings to pay your mortgage and other related living expenses?
I wouldn't be able to pay anything.
All right. Would that put you in financial peril or concern?
Absolutely, yes.
Financial peril or concern affect your ability to come in the four walls of this courtroom and provide these parties and their interests with your undivided attention?
Unfortunately, yes.
And you think that might also, or could that also affect your ability to be fair and impartial both to the state as well as to each individual defendant?
Unfortunately, yes.
Williams, is that correct?
Yes, sir. Mr. Steele will be here in the morning. I will be here in the afternoon.
All right, Mr. Williams. Fair enough. All right, madam, do you have any money in checking and savings?
I do.
I'm trying to get it past that.
Savings 10.
Okay, all right. Interest with your undivided attention.
Unfortunately, yes.
And you think that might also, or could that also affect your ability to be fair and impartial both to the state as well as to each individual defendant?
Unfortunately, yes.
All right, Mr. Smith, anything further, sir?
No, sir.
Anything further on behalf of any individual defendant? May I excuse juror 1719 for hardship? All right, ma'am, I'm going to go ahead and excuse you, okay?
Thank you.
All right, thank you, madam. All right, councilors, that concludes our hardship examination for this morning. A matter of housekeeping, Mr. Adams, Mr. Steele has sent us some correspondence in reference to an event he has tomorrow morning at 1:00. And he says that you have discussed that with Mr. Williams, is that correct?
Yes, sir. Mr. Steele will be here in the morning. I will be here in the afternoon.
All right, Mr. Williams, you okay with that? I'm going to include this letter that was emailed to me as the next court executive order. All right, councils, tomorrow.
Listen carefully for tomorrow, y'all. Listen carefully. Listen carefully.
Tomorrow we have some unrelated business in regards to TRO, I should say, as well as hardship. So we'll start at 9:00 and see where the day leads us. So Miss Fine, Kels, after I finish the matter involving the restraining order, we'll pick up with hardship examination, okay?
Thank you, Your Honor.
All right. Okay, any other further ministerial inquiry of me? Yes, Miss Love.
Does the court have any idea of how many jurors will have tomorrow?
I'm not Karnak, but no. I don't know, madam. In fact, Ms. Von Kelsch usually kind of gives me that list because I think that what she does, she calls during after the 7 o'clock hour, and then the list kind of gels up at that point in time. So I've stopped asking that question as well.
Thank you.
I can answer today.
Okay, all right.
It's going to be a full day. That is probably around 27.
Okay, and madam, just for educational purposes, how many people did we summon in group 7? And how many people have requested hardship?
Okay, let me get that information.
Counsel, I just wanted you to know this because this, for planning purposes, this is why it takes us a little bit of time to get through hardship. And for everyone else that's listening out there, we are working to exhaust the.
You see here, we heard what he said. For everybody that's listening out there, so that means we the people that's been listening to these hardship. So he's going to explain why it's taking so long.
These particular people that have hardships, but I want to say that there's
376 hardships.
out of
465.
yeah. So that's why it's going to take a little bit. So that's
Wow,
why we have to
y'all, did
move
y'all
through
hear
it
that?
At a decent.
Did y'all hear that? 376 hardship out of 465. 376 hardship out of 465. How many? Oh my God. That's almost 100%. Only 89 of 376 hardship. 376 hardship. Out of 465. Oh my God. 376 more people to do in number 7. Oh Lord, have mercy. Wow. Oh my God.
To finish those within about 2 weeks or thereabouts. Okay, anything else?
Yes, Your Honor.
Yes, Mr. Johnson.
With regards to the motions tomorrow, I'd like to possibly make that one motion for continuance.
The other parties aren't here. The states, these two representatives from the state are not going to be the lawyers that are representing the state of Georgia. I believe that the district attorney for Gwinnett County is in.
Okay. I'm gonna explain to you what's happening right here. Okay. You know, Mr. Johnson put in a paperwork regarding the computer thing here. Let me pull up the paperwork so you guys, I can explain to you guys exactly what is happening. And hold on a second. I'm gonna bring up the paperwork because I like to talk with paperwork. Hold on a second. Hold on a second. I'm pulling it up. I'm pulling it up. Okay, hold on. I gotta download it, and then I'm gonna put my my thing behind it, you know, my trusty old little what do you call it? Watermark. Just 1 second. Let me add my watermark on it, and then I'll be able to show it to you guys. Okay, hold on. Hold on. Download. Let's see the most one. Let's see. Did I get all of them? Hold on, y'all. Gotta put my watermark. Hold on. You know, I love my purple. Gotta put my purple in there. And then I got download it. And then I'm ready for y'all. Okay, here we go. Here we go. Okay, I'm going to read what this thing says, and then I'll give you guys my intake on it. I'm going to stop this recording here for a second. I'm going to take this brand off here. Let's go here. All right, I'm going to share this with you guys. All right, here we go. Can you guys see this? Should I make it bigger? Okay. Oh, wrong way, bigger. Make it wider. Can you guys see this? Can y'all see this? Let me know if you guys see this. Let me move out the way so you can see this. Hey, Doc. Can you guys see that? All right. It says here, emergency motion for a temporary restraining order and other relief. Now come Christian Eppinger by and through undersigned counsel and hereby file this emergency motion for temporary restraining order and other relief. Number 1, defendant Christian Eppinger is charged with the above referenced indictment and trial is in the case is underway. In this case is underway, with jury selection having commenced on January 4th, 2023. Eric is an attorney who is licensed to practice law in the state of Georgia, and Attorney Johnson is Mr. Eppinger's sole defense counsel on this case. Number 3, on May 30th, 2023, a search warrant was issued for the computer of Attorney Eric Johnson, to wit, a black HP laptop. Rather than execute this search warrant, when Attorney Johnson's bag was searched outside the courtroom prior to the start of court, law enforcement waited until the middle of the proceeding to execute this search warrant in the courtroom in the presence of the media and seized Attorney Johnson's black HP laptop while in Mr. Johnson's presence on May 31st, 2023. Upon information and belief, the magistrate judge who signed the search warrant was not advised that this computer belonged to an attorney and contains attorney-client privilege information and attorney work product. Pursuant to OCGA 17-5-32, there are special procedures to be followed when seeking to seize items in the custody of an attorney. Importantly, only a superior court can issue the search warrant OCGA 17-5-32 C5. Thus, on the face of this search warrant, this warrant is void and the computer must not be searched and must be returned to Attorney Johnson instantly. Number 6, OCGA 17-532B, search and seizure of a documentary evidence in possession of attorney specifically provide that notwithstanding any other provision of law, no search and seizure without a warrant shall be conducted on no search warrant shall be issued for any documentary evidence in the possession of an attorney who is not a criminal suspect. Oh. Unless the application for the search warrant specifies that the place to be searched is in the possession or custody of an attorney, and also shows that there is no probable cause to believe that the documentary evidence will be destroyed or secreted in the event a search warrant is not issued. This code section shall not impair the ability to serve such warrant in cases in which the search is directed against an attorney if there is probable cause to suspect such attorney has committed a crime. This code section shall not impair the ability to serve subpoenas on non-suspected attorneys. Number 7, for obvious reason and to protect the sacred attorney-client privilege, there are very strict guidelines for the search of a lawyer's computer as contained in 17-5-32C. Specifically, 1, at the time the warrant is issued, the court shall appoint a special master to accompany the person who will serve the warrant. The special master shall be an attorney who is a member in good standing of the State Bar of Georgia and who has been selected from the list of qualified attorney maintained by the State Bar of Georgia. Upon service of the warrant, the special master shall inform the party served of the specific item being sought. Oh, they didn't do that, y'all. Oh, okay. Let me finish reading. That shall have the opportunity to provide item requested. If the party in the judgment of the special master fail to provide the item requested, the special master shall conduct a search for the items in the area indicated in the search warrant. 2, if the party who has been served states that an item or items should not be disclosed, such items and items shall be sealed by the special master and taken to Superior Court for a hearing. At the hearing, the party whose premises has been searched shall be entitled to raise any issue such may be raised pursuant to Code Section 17-5-30, as well as claims that the item or items are privileged and claim that the item or items are inadmissible because they were obtained in violation of this code section. Any such hearing shall be held in a superior court. Number 3, any such warrant must, whenever practicable, be served during normal business hours. The law enforcement officer or prosecutor serving the warrant shall not participate in the search, but may accompany the special master when the special master is conducting the search. Number 4, any such warrant shall be served upon a party who appears to have possession or control of the item sought. If, after reasonable effort, the party served the warrant is unable to locate any such person, the special master shall seal and return to the court the determination by the court any item which appeared to be privileged. Number 5, any such warrant be issued only by Superior Court at the time of applying for such a warrant, the law enforcement officer or prosecutor shall submit a written search plan designed to minimize the intrusiveness of the search. When the warrant is executed, the special master carrying out the search shall have a duty to make reasonable effort to minimize the intrusiveness of the search. Number 8, none of the procedures specifically set forth in OGCA 17-5-32 were followed, rendering this seizure search illegal. Number 9, the search warrant at issue is on its face void and probable cause violative of OGCA 17-5-32 and breach attorney-client and work product privileges. This episode by the law enforcement arm of the prosecution team cannot be condoned. If Attorney Johnson's computer had been breached, search, a castigar hearing is required. Number 10, all counsel who represented co-defendant Mr. Eppinger joined this emergency motion. Wherefore, defendant, his counsel, and all attorney joining this motion respectively request A, that this court issue an order instanter preventing and restraining the state and any agency thereof, including the Fulton County District Attorney's Office and Fulton County Sheriff Department, Georgia Bureau of Investigation, and any other law enforcement agency, anyone that on the prosecution team, and anyone from gaining access and or searching this computer. B, that this court issued an order requiring the state to produce all documents related to any search already conducted of this computer. C, that this court conduct a castigar hearing related to the fruits of the search. D, that a special master be required to inform the party served of specific item to be sought, and that the rules set forth in 17-5-32C1 be complied with. E, that all items seized from the computer shall be executed and suppressed from the prosecution case in chief or in rebuttal, and such evidence shall not be admissible either in substantive evidence or for impeachment purposes pursuant to OCGA 17-5-32D. F, that any person or witness tainted by this improper conduct be removed from participating in this case forthwith, and G, that this court grant all other relief is deemed just and proper. Ooh, child. First day of June 2023. Whoa. Whoa, can you believe this? Wow. Wow. Okay, that's what the hearing is all about tomorrow. So, okay, the judge did respond. I'm going to show you what the judge said in his response. Let me pull up the judge's response. Okay, let me give you what the judge says. Here's what the judge said. Here's what the judge says in response to the judge. From the judge. Okay, y'all ready? All right. Here's the judge. Order granting temporary restraining order and other relief and order to show cause. Okay. The judge put in restraining orders. That means they cannot go into that computer. Ooh, child, this is a mess. All right, here's the what the Judge Glansville said. He said The defendant, through his counsel, has moved this court to issue a temporary restraining order preventing and restraining state and any agent thereof, including the Fulton County District Attorney's Office and Fulton County Sheriff Department, the Georgia Bureau of Investigation, any other law enforcement agency, anyone on the prosecution team, and any other person from gaining access to and or searching the computer of Attorney Eric Johnson, specifically a black HP 17 computer bearing the serial number 5CG9295QN4N. The defendant raises specifically justiciable issues regarding the search warrant under which this computer was seized. The judge. This court finds that the issue and argument raised by the defendant emergency motion for temporary restraining order and other relief must be litigated before any search of Mr. Johnson's computer is conducted. Okay, the judge has put his foot down on this one, y'all. All right, wherefore, judge said, I ain't in this. Wherefore, this court hereby order, with the big ORDERS, orders that the state and any agent thereof, including the Fulton County District Attorney's Office, the Fulton County Sheriff Department, Georgia Bureau of Investigation, and other law enforcement agency, anyone on the prosecution team, or any person from gaining access to and or searching this computer shall not, big capital SHALLNOT, not access or conduct any search of the Attorney Johnson's computer until a hearing in such the legality of the aforementioned search warrant is litigated. Additionally, this court ordered that the state, to include any agency listed above, shall produce all documents relating to the search already conducted on this computer and the names of all individuals who have accessed and searched Attorney Johnson's computer subsequently to its seizure. Additionally, this court orders that the Attorney Johnson's computer shall be returned to Attorney Johnson instanter and shall remain in his possession until a hearing of defendant motion is conducted and the court rule upon it. Additionally, Attorney Johnson shall not delete any file from his computer until the court rules upon this motion. Accordingly to all interest party hereby ordered to show cause before the Honorable Yule Glanville on the 8th day of June, 2023 at 9 a.m. in Courtroom 1C, 185 Central Avenue, SW, Atlanta, Georgia, 30303. With this court shall and shall not grant any relief requested by the defendant in his June 1st, 2023 emergency hearing for temporary restraining order and other relief. This second day of June, Honorable Yule Glanville. All right, y'all. Yes, they did go into his laptop already. So, guys, well. Tomorrow is going to be one of those days, and I got to be in that courtroom. I got to be in that courtroom. All right, I got to be in that courtroom. So, that is it. Any question in regard to YSL? Any question? Louisa, you're going to have to wait till next live because I'm going to be addressing R. Kelly stuff. So I haven't read anything you put in there. So you're going to have to rewrite it when we do R. Kelly updates. So, y'all, any questions in regard to what I just read? Lady Culture, and you're right. They did read it. Yep. So it's going down tomorrow. It's going down. Calling timber, you better move. Okay, and you notice they have Gwinnett County District Attorney's Office coming to represent the Fulton County, because they can't do it on their own, because the Fulton County Sheriff Department and the prosecution are working on the same team, so they can't be the prosecutor over what happened to the Sheriff Department. So they got to bring somebody from the outside in to look over, because if you did, it's going to be a conflict of interest, it's going to be impropriety situation and all that. So Lord have mercy. Well, I don't know what's going to happen, y'all. I don't know what's going to happen. I don't know what's going to happen. So, any questions? So, I'm about to end this and take a break, and then come back to do Mr. Kelly's update. Any question? I just wanted to read that to you guys. And so tomorrow there is going to be the hearing at 9 a.m. and I will be in the house of that. So guys, you're probably going to have to look at what's the name? Law and Crime. They're going to have it up. Law and Crime probably going to go and show it, and you guys get a chance to see what's going on with that. So tomorrow. All right. All right, guys, I'm about to leave, get off this live, and I'll see you guys in regards to YSL. See you guys tomorrow morning. And I'll be getting out the house real early, because traffic and the stupid drivers and all that. I'm gonna be getting up early, so catch me early in the morning, y'all. Early in the morning. I'll probably get out the house about 6:30. Early in the morning. I'll see you in the morning. But those who staying on, well, I'll be back in a few to do R. Kelly update, okay? And I'll see you guys later. Love you guys. Bye. Later. Toodaloo.